it could just be nonsense. It could be a rigmarole, or, hey, submit this again, or we don't have this piece of information, or can you send over the expert report? And when I'm talking to the homeowner, they're like, I've submitted this like 4 times. They have it. So for me, in my mind, I'm looking at that as, okay, they're kicking the can, or they're creating this sense of confusion or gaslighting, whatever you want to call it, to frustrate the homeowner, and maybe in hopes that the homeowner just goes away out of frustration. I'm Luke Carlson, and for almost 2 decades, my law firm, Ellis Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson, host of Bad HOA, the podcast. Welcome back. Today, I have Marty on the show.
Welcome. It's always great to be back. I can't believe we're back here again.
Yeah, no, this is great. And I love today's topic. I think it's very important. And what I wanted to discuss is, when do you need to hire a lawyer? When is lawyer intervention mission critical with a bad HOA?
Yeah, I think we go into that in the book, but it'd be great to like really break that down into like tangible 1, 2, 3, 4 steps here.
Yeah, what to spot.
Yeah.
And, as you know, we do thousands of consultations. And, what's interesting in the consultation space, what we look for is, sort of the first question is, does this person even need a lawyer?
Yeah.
Has it gotten so bad that lawyer intervention is warranted? And I think that's an important analysis, because if you look at, surgeons have a bad rap, right? If you injure yourself.
Surgeons have,
Yes, because if you go to a surgeon, a lot of them say, hey, you need surgery. Automatically, when there might be other methodologies that you can avoid surgery. And I happen to know a lot of surgeons, I don't know why, but the really good ones, in my opinion, they use that as sort of a last effort, right? It's not, you don't lead with surgery. And I think the same is true here. You don't necessarily always lead with hiring a lawyer.
Sure.
So yeah, today I really want to explore the space and see, maybe if we can identify a situation where, yes, I think lawyer intervention is required, but then also, try to do some self-help steps first before you, pull the trigger on the lawyer.
Yeah. Well, let's dive right into it here.
Yeah. So, from a attorney's perspective, when we see clients, one of the first things we look at is communication. My question is always, how much communication has been presented to, let's say, a bad HOA? And often if there's a dispute and I don't see much communication, meaning the board doesn't have the information to make a decision, I think that's a good stopping point for the lawyer intervention, and a time for the potential client to sort of reconsider and say, you know what, maybe I do need to communicate more to the board.
Well, let's break that down for a minute. So when you're talking communication, are you talking about all forms of communication? Hey, I ran into this person, in the street, and I wanted to talk to him. I said, oh yeah, we'll get back to you on that. Is it sending the emails? Is it making the phone calls? Break that down for me a little bit.
Yeah. So from a lawyer's perspective, if it's not in writing, it didn't happen.
Sure.
Right. So I like to look at emails. And nowadays you see text messages, and that's I think a viable way of communicating.
Yeah.
So I think written communications are one of the first files we look for. But then secondarily, the question is, have you gone to the board? Have you spoken to them? And maybe it's in an open session. And if that's the case, the question is, okay, what information did you provide? So even though it wasn't electronically transmitted, they may have showed up to a board hearing or a meeting with the board or an open session, and maybe they turned over a binder with all of the information.
Side note, are all official board meetings, are they supposed to take minutes in those meetings?
It sort of depends on the board.
Okay, but it's not a requirement.
Under the Davis-Sterling Act, certain yes, but others could be more open session. Or remember, we've spoken before about informal dispute resolution, IDR.
Yes.
Now, that's an interesting one, because if there is a lack of communication, I typically say, you know what, before you hire a law firm, hire us, hire LS Carlson Law, you might want to attempt IDR. And again, informal dispute resolution can be a very powerful tool.
Yeah.
Because 1, you don't need a lawyer, right? So you're not spending money on a lawyer. But 2, it forces the board to sit down with you, in theory, in good faith, to discuss the dispute at hand.
Yeah.
And when these work, they're tremendously effective.
Yeah.
And so I always look to see, what were those communications, what were those meetings, and what information was exchanged, right? I think
Yeah.
that's very important.
So let's break that down a little bit more. Um, are you looking for a lack of communication or hostile
Oh, great point. Yeah.
responses?
So first, I look for bare bones. What has been communicated to the board?
Okay.
Has the position been made clearly, effectively? But I also look at the response,
Yeah.
right? How did the board respond to this? And I've seen homeowners who have really laid out their case nicely in a very sophisticated way,
Yeah.
lack of emotion, very factual. Hey, this is the problem. This is the CCNRs. This is what we're seeking. Please advise. And if I see a very bombastic or hostile response, I may say, IDR is probably going to be a waste of your time.
Yeah.
So I do look for that. I look at the tone of the association or the board members. Um, but I also factor in this sort of game that a lot of HOAs play too.
Hmm.
And so the communication may not be hostile, but it may very well be, hey, thank you for submitting. Can you please submit additional documents? Can you, resubmit this piece of paper? And often that's sort of a game that they're playing, right? They're moving the target. They're acting like they never received something when they did. And if I see the homeowner say, okay, here it is again for the third time, at that point, I think that there is some sort of breakdown within the relationship.
Oh, you think they're playing games, saying they're
do.
trying to kick it down the road and say, hey, maybe this problem just goes away.
Yeah,
Or-
because a bad HOA doesn't always manifest in hostility,
yeah.
right, or overt aggression. It could just be nonsense. It could be a rigmarole, or hey, submit this again, or we don't have this piece of information, or can you send over the expert report? And when I'm talking to the homeowner, they're like, I've submitted this like 4 times. They have it. So
Yeah.
for me, in my mind, I'm looking at that as, okay, they're kicking the can, or they're creating this sense of confusion or gaslighting, whatever you want to call it, to frustrate the homeowner, and maybe in hopes that the homeowner just goes away out of frustration.
Interesting. Okay, so looking at communication, determine the nature of the responses or lack thereof. So would
Correct.
you say one of the first indicators of needing to hire a lawyer is the hostility, potential hostility, number
Right, or
one.
aggression, yeah.
Them kind of giving you the runaround,
Right.
number two, or just ghosting you altogether.
Yeah, I guess ghosting would be the third category.
Yeah.
So, the first thing we look for is the communication with the board hostile?
Yeah.
And if it's hostile, maybe it's time to lawyer up. Or maybe it is the runaround. It's gamesmanship, right? They keep asking for the same document. They want the information over and over and over again. At that point, it's not in good faith in my mind. There might be some bad faith infused into that dynamic.
So bringing on IDR in those 3 scenarios, hostile, may or may not want.
Hostile, I'd probably avoid IDR.
Ghosting, that seems like a one that you could send, or
Ghosting is interesting.
Yeah.
If there's a ghosting scenario, I may recommend IDR. And if they ghost the IDR, that actually turns into potential evidence down the road as bad faith.
Okay.
Because here the homeowner demanded informal dispute resolution under Davis Sterling, and it was ignored.
Okay. So what about kick the can?
Kick the can, IDR might be a viable option still.
Okay, because you have some communication standard like in place.
You do, and then at that point, it's very hard for a board to say, well, we didn't get it when there was a meeting when they said, here's the document you requested.
Yeah.
It's hard to sort of derail that sort of exchange, right? They can't say, well, you never gave it to me. Well, I gave it to you in front of 5 people.
I think it's also worth noting for those that just tuned into this particular episode, we have an entire episode on the IDR process and what it is and how to enforce your rights, at least here in California. It's well worth the listen.
Yeah, it's a powerful tool.
Yeah.
And I think the Davis Sterling Act did a really great job putting it in. And like I said, when it works, it's very useful.
Yeah.
I think it has high utility and high value. But again, caveat, when it works.
Yeah. Yeah.
Right. Or when it's well received.
Yeah.
But with a bad HOA, it's not going to, I don't see that as being a very effective means of actually resolving a dispute.
Okay. So communication, what's the next one?
Well, putting for a second, when we look at communication, there's a point I want to make.
Okay.
Often, if information is being exchanged with a board, it doesn't necessarily arise to sort of, in my mind, it's always a level up, which is the attorney. Because oftentimes I think there's an assumption. If the homeowner turns over everything to the board, the legal legal counsel of the board is going to be reviewing it. That's not always the case.
Mm.
And often I've seen when we actually finally speak with the opposition counsel, they have no idea this dispute exists in the first place. They're like, I had no idea the board was doing
They
this.
never brought
It was never brought to the attention, right?
Yeah.
So it was concealed. So that becomes also sort of problematic, and it especially sort of shows as to why a board keeps doing bad things, because they never bring it to sort of the adult in the room, or at least in theory, the adult in the room.
Sure.
Now, there are times where the attorney gets involved and is sort of weaponized, right? I've seen those fact patterns. But, in sort of the ideal situation, if the information from the homeowner who is aggrieved gets into the hands of the attorney, hopefully that attorney does the right thing
Yeah.
and sort of sets the board straight.
Yeah. So let's talk about that, I guess, in terms of steps. If an attorney comes back at you, do you think, okay, so you filed the complaint or you've tried to bring something up, some sort of dispute
You've identified
arises,
a dispute, you've backed it with evidence, you've turned it over to the board.
and the board immediately turns it over to the attorney. Do the homeowners typically get communication directly from that attorney?
They can.
They can.
Yeah. And sometimes it's a response from that lawyer.
Okay.
And what's interesting is we often see responses that are so one-sided.
Sure.
Right?
Of course. They're representing the
yeah.
the HOA.
They're not agnostic. They're not reasonable or even keeled. It's typically very aggressive towards the homeowner. And I would say at that point, that might be a very good triggering event to start talking to a lawyer, because they've lawyered up.
Yeah.
Right? They have an advocate, and arguably there might be a target on your back in some way, shape, or form.
If they bring in another attorney, if they bring in their attorney, it's likely to, it's time to bring someone on.
Or at least consult with a lawyer.
Yeah.
At that point, you should be talking to a lawyer as well, who understands this area of the law, who's sophisticated with the Davis-Sterling Act, who understands the CC&Rs.
Yeah.
At that point, I think that's a very wise decision.
Yeah.
You don't want to, go pro per and start battling it out with a lawyer.
Yeah.
Necessarily.
Yeah. And to that effect, I could see a lot of lawyers on that side trying to set the traps. Like when you don't have representation on your side, like trying to walk you into, well, wait, you said that you did this or X,
Right.
Y, and
And
Z.
I've seen that before too.
Sure.
I've had admissions. They weren't even correct admissions, but the attorney outmaneuvered the homeowner.
Yep.
And now the paper trail is somewhat defective because of what, the back and forth with that lawyer for over a period of time.
Right.
So that becomes dicey waters, if you will. And you should have a high guard. And you should bring in someone who really understands this area to ensure you're not hitting a tripwire, which is going to be set for you, or could be set for you.
Sure. Okay. Let's keep pressing on.
Yeah. So I think going back to overt aggression from the board, right? If you're seeing that, that often leads to some sort of lawyer intervention on their side. So that's sort of a red flag for me. If I see very hostile board members, or if I see text messages which are very hostile or accusatory, right? If there's an allegation that you're violating the CC&Rs, or if you're engaged in some sort of misconduct, that allegation shouldn't stand without any sort of response or rebuttal, right? You shouldn't just not say anything. I think there should be a rebuttal, and often that rebuttal is likely from your lawyer, right? That's a good time to maybe consider talking to a lawyer, and if the facts of the case warrant it, actually onboard that lawyer to respond.
So realistically, what we're saying is, if the board is extremely hostile, it's almost inevitable that lawyer intervention is inevitable
on some level, right?
Yeah.
And again, when dealing with lawyers, it's not necessarily an all or nothing proposition.
Sure.
Most law firms have consultations. Sitting down with someone who understands this area of the law is very, I think it can be very educational.
Yeah.
And sort of lifts the fog of war, so you start to see things for how they really are.
Yeah.
Because you're getting one side, which is often painted in a very skewed way. And it's often against you, right?
Yeah.
So you want someone to come in and say, okay, well, here's why their arguments are incorrect.
Yeah.
Here's what they're trying to do here. Here's how we might be able to outmaneuver it strategically.
Yeah.
Right. And I think that's a very important conversation to have before things go further down that rabbit hole.
I've seen a lot of disputes, at least the ones that complain online, really arise from egregious fines. In two camps. Number one, they get a fine for a parking violation, but it's so astronomical, or they just keep getting them, right? Or the homeowner will claim this is not in our CCNRs. Right. So I think both of those things can be true. So can you speak to those two potential disputes?
Yeah. So that's another form of aggression, I would say, fines or penalties. And what you have to look for there is, first, was there even a violation? Some of our clients come in and they're like, yeah, I have $7,000 in fines and violations, but I never engaged in this conduct. Or what's another interesting one is, yes, I'm getting these fines, but 70 people in my neighborhood are doing the exact same thing. I've spoken to them and not one of them has gotten a fine.
So selective enforcement.
So now you have a selective enforcement issue.
Yeah.
And so what an attorney can do, a good attorney can look at that and say, you know what, this is a breach of the CCNRs or a violation of Davis Sterling.
Yeah.
Or, it's sort of in that selective enforcement or preferential treatment camp, right?
Yeah.
And then now the homeowner is empowered by way of enforcing their rights against an association who's engaged in that scenario overreach.
Would you say let's wind it back to selective enforcement.
Yes.
In that scenario, do you think that's an automatic trigger to go to a lawyer, or do you call it out first and try to go walk your way through and talk to them reasonably and work through potential IDR process? I guess it really depends on how the board is.
I think it's the makeup of the board, right? It's the DNA.
Yeah.
Who are we dealing with? Is it a tyrant?
Yeah.
Then maybe your first call is to a lawyer. It could be inadvertence, though. They could just happen to be sending out these fines unknowingly. Maybe the management company is off. So it really is a case-by-case basis.
Yeah.
But you got to look at what's driving it, maybe behind the scenes, if you know the motivation. And if you know Bill on the board just doesn't like you, then you kind of have some intel on sort of the psychology driving that.
Yeah.
But if it's something where you don't really identify motive and it seems somewhat random, it might not be bad to call the board out first.
Sure.
And by the way, if you do, let's say if you go through IDR, you might get some intel from that meeting and you can bring it to that attorney. So the attorney's in a better position to enforce your rights.
What about the fines on things that the board just... I've seen online a lot of people say, I got fined for something I didn't even know existed. Is there times where you see people getting fines for rules that were just added without...
Well, the cliche is ignorance is no defense. Right?
100%. But what if, I guess what I'm getting at is, can a board just add a rule, just like with a flip of a wrist?
Well,
and say,
there's
hey,
procedure. It's procedure, right? So you look at your CCNRs, you look at the bylaws. It depends on what type of rule. Some require voting. Some require, different mechanisms, right, to get it into play.
Yeah.
But often with any new rule or new amendment to the CCNRs, there's a notice period.
Yeah.
Right? They're notified, and it's typically, hey, this will go into effect on this day. Now, if there's lack of notice, if there's lack of procedure, there might be a due process issue there. So, if it's one where there's questions around those topics or those subjects, get a good lawyer to look at it.
Yeah.
And they may say, hey, this violates due process, or this is inconsistent with the bylaws, or this is just moot or void because they didn't follow proper procedure.
Yeah.
So there might be a way to attack it on those lines.
Yeah.
But again, that's really a lawyer examination.
Yeah. I could see a lot of disputes. And again, another one that pops up a lot is condos because of shared walls. Like you own the air inside the walls, but anything beyond those inner walls, it's not yours.
Yeah, because you have common area between, and yes.
Yeah. Failure to maintain it seems like a lightning rod for like plumbing issues and roofing and leaks and all that fun stuff. I guess on the same side, what do you define as a good time to lawyer up in those particular scenarios?
Yeah, failure to maintain is interesting because let's say you're dealing with a common area pipe that burst because of lack of maintenance, right?
Yeah.
And it floods your unit. $100,000 damage, property damage.
Yeah.
And you go to the board and say, hey, I have this massive water intrusion event. I'm looking for compensation. Can you work with me? And they say, hey, it's not our problem. That's a you problem. We're not responsible. Or, it's something along the lines of, no, we're not responsible. Tender to your insurance.
Oh,
right.
Yeah.
There's certain things that they're trying to push back to avoid that liability.
Yeah.
So, if you're looking at substantial property damage, it might be an automatic go to the lawyer. you may not want to waste time going back and forth, because especially with water intrusion, your condo could be destroyed or at least partially destroyed. You might be displaced. So there's a lot of interference in your life. And boards are very notorious for kicking the can, drawing these things out. And, 4 months down the road, you're still not compensated from the HOA. You're still living in an Airbnb and with no end in sight.
Yeah.
So I think with something more substantial, especially if it's coming from a common area, it's wise to at least consult with a lawyer, at least.
What about the first signs? For instance, we live in Southern California. Rain isn't prevalent,
right.
But when it does come, it usually comes with fury, right? You live in a condo. We get some rain, and all of a sudden you see the water stain in the drywall, right? It's clearly a roofing issue at that point. Do you bring on a lawyer right then and there and say, hey, we have a problem, or do you try to get it resolved? And then at that point, if they don't respond to you, then it's time to bring someone on.
Something like that, I would bring it to their attention immediately.
Yeah.
Because honestly, they may have no idea.
Yeah, for sure.
Right. And so if you can bring it to the board's attention, maybe even through IDR, if they don't respond to the first couple of emails, and then sit down with them and say, hey, we have a real problem. It just rained. Here's the photographs. I need this resolved. And they say, okay, we'll look at it. And you never hear from them. Or they say, well, they're doing sort of the lip service thing.
Yeah.
At that point, you may just want to go to a lawyer, get ahead of it before the next big rain event occurs.
Yeah.
Because, that could be devastating. Right now, it's sort of minor, but those things, typically expand in scope. They don't, shrink in scope.
Yeah, absolutely. Okay.
So I think on a common area especially. And what's interesting too, we had a case last week where our client was next to a greenbelt, beautiful greenbelt, common area greenbelt, and there was problems with the drainage. So she goes to the board and says, hey, this keeps backing up. You got to fix this. And I read the lawyer's letter, and in the letter from the lawyer, it says, dear so-and-so, we are not obligated to maintain the common area. This is discretionary. It's at the board's choosing an election. So we are going to take no further action. Pull up the CC&Rs, it's black and white. So you got to realize, even if someone is saying something, you got to get it checked. You got to get it verified. You got to confirm, right?
Yeah.
Because, if they're on the defensive, if they're constantly trying to push away these problems, and no one pushes back, then they're going to be successful. If she just got the letter and said, oh, I guess it's discretionary, she would have lived with that reality. And next big rain event, maybe her property would have been damaged tremendously.
Right.
But, she got it verified. We realized that they were just dead wrong, and we were able to take action, and actually we're, moving forward accordingly.
Yeah, that's interesting. It seems so many things you could just go back to your CC&Rs and just say, this is or isn't in there. Here's my problem. This is or isn't in there. And that seems like a really good spot for a homeowner to start. If they're saying, hey, you can't do this, or you can do this, or we're not responsible for X, Y, and Z, go to your CC&Rs first and then try to fight it back.
Well, I think the basis of the show has always been empowerment.
Yeah.
How do you empower homeowners, right?
Yeah.
And CC&Rs are such a vital tool.
Yeah.
And even a simple read. I mean, just because someone says something, just because a board says something, verify it.
Yeah.
And it doesn't take long.
Yeah.
Right. And, you'll often find that, hey, the board is not being forthcoming.
Yeah.
And then when that happens, you can push back, you can go through IDR. But if none of that works, I think that's the time to speak with somebody.
Yeah.
Speak with a lawyer, get it to a point where you know what your rights are, and you also know how to prosecute those rights.
Yeah.
Because there's different ways to move these cases forward, but you should know all your options.
Yeah.
As opposed to kind of living in that fog of war.
Yeah.
So
what else did we miss, or did we potentially miss?
I think that was fairly comprehensive. I mean, those were the basic things that we see time and time again. Again, I think a good consulting attorney will verify, okay, does the attorney intervention, is that even warranted?
Yeah.
Right. I think that's very important.
Yeah.
Because again, like the surgeon, if you go to them and you're immediately like, yep, we're doing surgery without a true exhaustive analysis, that's problematic. That's a red flag.
Did you see the show Dr. Death?
No.
It's about a surgeon that literally just goes right for, is doing exactly what you say. And so many cases where he butchered them, and some resulted in death.
Okay, that's horrible.
I know.
Yeah.
I know. Anyway,
I didn't see it, but I guess that's my point. Not every single dispute that arises in an HOA requires a lawyer. It just
Yeah.
doesn't. But when it does, there's a lot of value in bringing on the right attorney.
So let's try to recap just a little bit. I guess one of the big things I think I took away from this was number one, if the board is being combative or they're incredibly aggressive, time to lawyer up. If you put in make some sort of request and it goes and a lawyer responds, probably time to lawyer up. If they're giving you the runaround and you just keep jumping through hoops and you've provided the things that they've asked for multiple times and they're just giving you the runaround, maybe time to lawyer up.
Right.
If you have looked at your CC&Rs and they're claiming you did X, or they're not responsible for a particular thing, look at your CC&R. If there's any variance in the CC&Rs where they're claiming one thing, you're claiming another, and the CC&Rs are clear, and they're not going to respond to it.
There's a disconnect there.
There's a disconnect there, and they're not willing to respond to it. Time to lawyer up.
Yeah, I in a nutshell, it's, if there is, the question is, when do you lawyer up?
Yes.
Right? Hostile, aggressive boards. If they're being hostile and aggressive, you may want to consult with a lawyer. 2, if they're gaslighting you or gaslamping you, right? Like you're giving them the information and they keep saying they don't have it, or they keep moving those marks, right?
Yes.
Or those targets. That's a good time. 3, if you get hit with a lawyer letter, if they've weaponized a lawyer and that lawyer's coming after you, you may want to talk to a lawyer.
Yeah.
And then I think 4 is property damage. If you have significant property damage, you might just want to go straight to that lawyer.
It's a good recap.
Yeah. So, but yeah, I think at this point, this is a good starting point for, the homeowner start thinking about the process, understanding, okay, maybe I start with the CC&Rs, I look at the communication, I look at the posturing of the board.
Yeah.
Because, ultimately bringing in a lawyer is a big decision. You want to put some thought and, intellectual rigor behind that.
Yeah. And we have lots of episodes too on how to prepare for consultations and on all of those things. But I think it's worth mentioning too, just because you consult with a lawyer doesn't mean that you're retaining a lawyer, but just to get some clarity, right? If these come about, you're not obligated to retain.
It's almost, as I see a consultation, it's like an X-ray.
Yeah.
Right. Someone is examining it almost in a clinical, objective way.
Yeah.
Saying, okay, is the bone broken? Is it fractured? And then what can we do about it?
Yeah.
That's a good consultation.
Okay.
And then you make a decision after that X-ray.
But I have kind of a funny question.
Yes.
Okay. Have you ever, I'm sure you have, but have you had a consultation and you realize the homeowner's just dead wrong and you have to lay it out to them?
Well, of course.
Yeah.
I think that's, with any consultation, you can't expect that the homeowner understands all of the Davis-Sterling Act or understands the nuances sometimes in CC&Rs or the ambiguities. And, if they're going in the wrong direction, it's incumbent upon the attorney to tell them not only, hey, this is why this is incorrect, but maybe there's a different way to look at it.
Yeah.
Maybe they're wrong in their understanding, but they're not wrong in terms of the fact that they're dealing with a bad HOA that may have violated different rights than what they think. So no, I think that consultation has to be clinical in the sense of, if the homeowner comes in under a misunderstanding of law, your job is to correct that.
And I would assume in some situations, some homeowners just want to steamroll their HOA because they're mad at them for whatever reason.
Sometimes you can, right? I mean, the conduct is so egregious.
But I'm talking about, what if it isn't egregious and the homeowner is just like, I'm going to steamroll you, I have the money to do so, and they just want to bring in a lawyer just to stick it to them. And then sometimes you're on the other end and say, you don't really have anything here. I'm assuming that comes up too.
All the time.
Yeah.
And we have a fiduciary to explain it to why.
Yeah.
Why you can't do that.
Yeah.
You have this law, this body of law, and lawyers operate within that body of law. Yeah. And if they want to hit targets that are way outside of that, you can't do it.
Yeah.
So sometimes you have to be the, bearer of bad news. And I get the emotion though. I get why, right? Because it's a very frustrating situation. But at the same time, you need good intel. You need a good diagnostic.
Yeah.
Or, analysis.
Yeah.
Right. So good question though.
Yeah. I like it.
Good. All right. So thank you guys for joining us. Hopefully you found that helpful. Please subscribe, like the video, and also leave comments. We love the comments.
We love the comments, and we do our best to respond to any comments that we can outside of giving legal advice.
Right. All right, guys. Till next time.